Good afternoon and welcome. It's an extraordinary privilege for me this afternoon. I must thank Pierre and Praha and Helen for inviting me to do this, to introduce Albie Sachs. I've never had the opportunity to do this before, so he's going to have to bear with me for just a second. I'm going to do it in two forms. I'm going to give you a formal kind of short bio, and then I'm going to give you my impressions of it from my own life. So firstly, Albie Sachs received his law degree from the University of Cape Town, having grown up in South Africa, born and grown up. He practiced as an advocate of the Supreme Court of South Africa for a decade, mainly representing dispossessed people and political activists. He was then detained twice for periods of time without trial, and he eventually left to the United Kingdom, withdrew strategically, as we used to say in that time. He completed his doctoral studies here and took a position as a senior lecturer in law at the University of Southampton. He then went on to complete his PhD and went in the late 70s as a professor and legal advisor to the newly liberated Mozambique. He subsequently served on the ANC Constitutional Committee and then was appointed to the first bench of South Africa's Constitutional Court. And that's the formal introduction. From my own experience, I was a young activist in South Africa in 1976. Albie was long gone, his works were banned, we could not read anything, but we knew of these people. In 1979, I arrived in exile in Botswana, a neighboring country where I arrived as a refugee. And there on the bookshelves of fellow refugees and exiles, one started to find the books. So I found the diary of Albie Sachs as his imprisonment. And you started to learn a little. But over time, I got a fuller picture of Albie, and I'm going to present it to you in 7 brief snapshots, images, if I had photos, and there are photos for most of these moments. As a student protester and a young man, Albie Sachs wished to join the Defiance campaign. He was 17 years old, and he was told that he was not allowed to do that, and he wasn't pleased at the time. So the story goes. Then there's a photo of him standing at the time when the Freedom Charter was adopted at the Congress of the People. And he's standing there with his thumb raised in the air in the Congress salute of the time. And that's the moment when the Freedom Charter is born. And later he's working alongside Frelimo for the legal construction of Mozambique. And again, for us young activists, this was extraordinary to see our leaders doing these things. In Kabwe, in 1985 in Zambia, the ANC held its Congress. And Albie's task was to he stood before the membership of the ANC at the time. There had just been a military raid into Botswana where many of comrades had been killed and where people were very angry and calling for war to continue. And Albie stood and justified and argued for why a Bill of Rights and why a code of conduct for the behavior of ANC people in exile for our security forces. Later, when I first actually ran into Albie was when I was serving as a very young lawyer now, having survived being an activist. I was now a young lawyer working for Zola Square, who was chairing the ANC's Constitutional Committee. And in that capacity, I ran around, carrying things and doing things like that young lawyers do. And Albie was on the committee itself. And so I got to know him personally during that period. And as I said earlier, and then at that point, we were still all advocates struggling for what we thought was the right thing. And then there came a moment when Albie said, well, he'd all his life been a member of the ANC. He was not going to be a member of the ANC because he was going to the Constitutional Court. It was an extraordinary moment for us, but one we came to understand. So please join me in welcoming Albie Sachs to talk to us.
One of the speakers said how difficult it was to be speaking about somebody in fairly intimate detail when that person was sitting in the room. There's one thing worse than that, to be the person who was sitting in the room. It was actually quite gruesome. From a distance, it was fantastic. I've got a big capacity for narcissism. And wow, was it invigorated by this invitation to not only come, but to bring my book, in which I'd invested so much, and to be discussed by people taking it seriously. That was fantastic. At a distance, it was marvelous. Close up, it's gruesome. I almost feel like I'm lying in my, we say coffin, you say casket, and people are saying things about you in an objective way, you know, as though you're dead. Or either dead or somehow transcendent. And I don't want to be either dead or transcendent. Somewhere in between, kind of living. But can I say to the speakers beforehand, it's been extremely moving for me. Not easy, but deeply moving. Moving to feel that your ideas are being taken seriously. One of my colleagues, Jan Kriegler, has commented on how lonely it is to be a judge. And people who haven't been judges don't understand that. Why should it be lonely? You've got your independence, you've got your salary, guaranteed. Only a revolution can take your salary away from you. You've got colleagues, you're in the public eye, hello judge, hello judge. And yet, at times, you feel intensely lonely. And that's because it's you and your conscience. And your conscience suddenly becomes very central to your life. Not just ethical choices that everybody makes, but professional choices, which maybe, I don't know, maybe a bishop can attest to something similar, I don't know. And it's profound and deep. It's constitutive of who you are. And you do things where, when I circulated the manuscript of Strange Alchemy of Life and Law, one of the first persons I sent it to was Stephen Sedley. Anybody in this room know Stephen Sedley or of him? Hands up. A very, very wonderful colleague, judge on the, very senior judge in the UK, very, very progressive. He's been my friend for decades. And he loved the book and he hated the book. He was so alarmed. He liked the tone, the thrust, the argument. He couldn't bear the fact that I was citing myself. You just don't do it. If you're a judge, your judgments speak for themselves, and somehow it's the height of egotism, if you like, a violation of a profound principle of judicial modesty. You say it in your judgments, you step back, you allow the others to comment on it. Now, I take Stephen very seriously. He's very progressive. He was the one who introduced me to the statement that a philosopher in Cambridge in the 30s had brought out: nothing should ever be done for the first time. Because if it should have been done for the first time, it would have been done already. And that, he said, was the prevailing ethos in Oxford and Cambridge in those days. So Stephen was very, very open to new ideas. But this was somehow a violation of, and it's often these hidden assumptions that are more powerful than the rules. The rules, you know, they're there, they're challengeable. The hidden assumptions are existential. They're characteristic of who you are. And I was violating that. Stephen, I was right. Today's proceedings, as far as I'm concerned, these are deep inner discussions one has, indicate that judicial mystique is valuable. A certain measure of reverence, if you like, or for the function, for the role. A kind of a resonance, a sense of significance, that this isn't just an ordinary statement. This is part and parcel of something called the law. And judges have a very special responsibility in that connection. So one doesn't have to become like a super realist in America, that your decisions are based on your digestion in the morning, if you like your breakfast or not. It's unfortunate, I think, to have a super realism that becomes super cynical. But what has to be stripped away? I've been so excited on the Constitutional Court, appointed as a judge, never having imagined I could ever be a judge, never wanting to be a judge. Glad that people I knew and respected were judges, but it was completely out of my mind, completely. It was never an ambition. And suddenly we're getting a new constitution. Getting the constitution, for me, my generation, was more than just a document that would help heal the country. It was healing me, a split Albie. Not split simply in terms of apartheid, vicious law, rule by law, not rule of law. That was easy to handle. But the contradictory twin nature of law. Albie, the young law student, in the opening of the book, learning the phrases about the rule of law and justice and repeating them in my exams and getting reasonable marks, which the professors believed in. And then at night going to teach in a shanty somewhere. It's dark, there's candlelight only. You see the eyes of people, the teeth, candlelight. The human expression is so intense. And here were people who hated the law. The law was the enemy. The law chased them. The law locked them up. The law knocked down their homes. The law demanded their passes. The law said, what are you doing out on the streets after curfew hour? The law was the enemy. But justice, they would give their lives for justice. And I was torn. I was torn. And it's never good to be a divided self. Unless the division, the contradiction, finds a way of resolving itself in a productive manner. And that only came about when we came to write the Constitution. Suddenly these beautiful, wonderful phrases of the ages that I'd put in my essays to pass my exams, which were the product of human endeavor, resistance, fighting against oppression in many continents and many countries, and sometimes codified, sometimes not. Suddenly the values expressed became important for our country. We would never have a country unless we could have these foundational principles and rules of justice, of fairness, of openness. At the same time, the passion of the poor, the willingness to give their lives for justice. The professors wouldn't give their lives for justice. They would give good marks for justice. And they would speak out for justice. And they'd write beautifully about justice. They wouldn't give their lives for justice. The poor would give their lives for justice. Suddenly they came together. And in creating our constitutional order, we needed the beautiful phrases, the grand ideas, which are products of human endeavor throughout the world, but we also needed the passion of the poor, bringing them together. And then in healing our society through the Constitution, I was healing myself without even being conscious of it at the time. So the decision to become a judge, or to be available to be a judge, it wasn't an abrupt rupture for me. It was a rapture, not a rupture. the Constitution embodied what we've been fighting for. Those principles were now incorporated in a document that would create a South Africa based on common citizenship, recognition of the dignity of everybody, with institutions to protect that, not just the vote, elections, not just a Bill of Rights, judiciary, but a whole range of carefully thought through mechanisms to ensure that oppression would not be normal, would not be acceptable, that discontent could be challenged into forms of mobilization, channeled into forms of mobilization that bring about real changes in the country. So for me, it represented a continuity. If anything, going into politics and running for office would have represented the discontinuity for me. I still remember at the time, now suddenly we've got our constitution, we're having elections, and there are 4 of us lawyers from the Constitutional Committee on the National Executive of the ANC. Who's going to be the Minister of Justice? Will it be Zola? Will it be Kader? Will it be Dalla? Will it be Albie? Am I going to be waiting for the phone to ring? Is this what I've been investing my life in? I'm waiting. Will Mandela ring and say, hello? I didn't like that idea. But the idea of being a judge on the Constitutional Court to defend the things we've been fighting for was very profoundly satisfying for me. In a sense, the volunteer, if you're born into an oppressed community, you fight against it because you're with the community fighting against it. If you're born into a revolutionary family, it's an idea that you grow up with. And you are the volunteer, and you don't blame history. You get blown up and you lose an arm, you're thrown into jail. That is part and parcel of the journey. You accept it, you don't accept it with joy, but you accept it and you try and get through. So now that idea of being a volunteer for freedom, in a sense, is carried forward for me by being on the court. It's nice if you volunteer, if as I said, your salary is protected by the Constitution and your independence. But for me, it was a continuation. The evolution also for me was important in opening up my mind, my spirit, to the new requirements of that new period in South Africa. We longed for certainty, and we had a sense of certainty, historical certainty, necessity of transformation, of revolution, of the poor, the masses inheriting the earth, establishing people's power, creating a just society for everybody. Living in Mozambique was an amazing experience for me. It was the time of the revolution. You could use the word revolution with pride. It was actually a very, very wonderful experience to have. And suddenly all these old verities seemed true. Yes, gosh, after all the dismay and the setbacks in other revolutionary countries and disappointments, it seemed to be uniting the people. It couldn't be sustained. There had to be place for opposition. I got converted to pluralism not through reading Karl Popper and the Open Society, but through living in Mozambique through the revolutionary period and seeing that if you don't have space for opposition, it doesn't go away. It goes underground, it goes across the borders, it becomes internationalized, and you end up with bitter civil war and with thousands and thousands of people, mainly without legs because of mines. We had to have pluralism. We had to have diversity. All that's built into our new constitutional order. And yet, you've got the Constitution. You've got a tradition of a very erudite judiciary in South Africa. I used to feel so conflicted as well. I'd love going down into the, we call it the Supreme Court, Cape Division, with my gown flying, all excited, hyped up for the argument, for the debate, the discussion. And yet the atmosphere was white judges, whites in charge. All the time the hidden colonial racist assumptions were kind of there, and yet you could debate, you could argue, you could discuss. You could use technical points to try and defend people. But there were a whole set of assumptions drawn very much from judicial practice and experience in the UK that just didn't seem to correspond to the new constitutional order we were in. We couldn't use South African precedent, the precedent of the years of apartheid and the years of parliamentary sovereignty. All those canons of construction and the intention of Parliament, which was foundational to everything we did, suddenly didn't belong anymore to the new world we were in. And yet we wanted to be taken seriously as judges. And just before I mention that, I wasn't the person who brought the Bill of Rights into the ANC. I was a Bill of Rights skeptic. You don't judicialize the important issues, let them be fought out politically in the streets, in Parliament, and so on. Oliver Tambo, when I give a lecture now in South Africa, I start off by saying, if you did a paternity test on the South African Constitution, whose DNA would come up? And people say, Nelson Mandela. I say, no. They say, you? No. They give up. I say, Oliver Tambo. And he was the president of the ANC in exile. And he was the one who saw a Bill of Rights was the answer to group rights in South Africa. The big constitutional battle was over group rights, which meant you'd have power sharing between black and whites. Blacks represented by blacks, maybe Zulu speakers by Zulu speakers, whites by whites, maybe by Afrikaners, in a single institutional arrangement. And getting huge support all over the world. You've got to understand, blacks and whites have been fighting each other. You need checks and balances between blacks and whites. And his answer was to say, no, we protect people not because they're white or black or belong to a minority or majority or Zulu speaking or English speaking or Afrikaans speaking or Tswana speaking. We protect people because they're human beings. Without that, we don't get a South Africa. Without that, we're finished. Without that, the Constitution becomes a barrier to change. Only a Constitution that recognizes that universal principle of fundamental equality based on human dignity can function in South Africa and can ensure that we get majority rule, which means black majority rule in South Africa, but in a framework that would prevent abuse of anybody by anybody, whoever the anybody and the everybody might be. And one reason for that, and again when I lecture then, I might as well pass this on to you. I say, 1988 in Lusaka, we're having a conference on constitutional principles for a new South Africa, and I'm going to the platform to speak. My heart's going boom, 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 because I'm going to speak on why we need a Bill of Rights. And I say, there are three reasons. The one, it makes us look good. Of course, everybody nods. And now we've got people, these are revolutionaries sitting in the audience, not law students, people belonging to the army, diplomats working in the underground. Second, I give the Oliver Tambo reason. It's our strategic answer to group rights that's based on ethnicity. And I said the third reason, and that's why my heart's going boom, 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 is because we need a Bill of Rights against ourselves. And we'd seen in countries we'd lived in, people had fought bravely for their freedom. They get into power and authority and often become very authoritarian. And I'm thinking, how are the comrades going to react? Okay, for Albie the lawyer, you know, it's easy for them. And there was a look not of repudiation, but a look of delight, because that's what people were thinking. We'd seen problems inside our own organization of abuse of power. How will we be when we're in power? So all of these are themes now that are going into this document we call the Constitution. I didn't like our forms of judgment writing. But who am I? We've had judges who very progressive, very thoughtful, brilliant, who'd been judges before, honest, hated apartheid, overjoyed by our new constitution, the changes in South Africa. But they would start their judgments. The applicant in this matter is a 45-year-old businessman, such and such. The defendant is so-and-so, so-and-so, and you have to get to page 3 before you even know what the issue is. So I like to start, this case is about. I'm happy to say now all the judgments start with setting out the issue. But it wasn't automatic. And I felt uncomfortable. But I couldn't do it. I didn't think like that. I thought in terms of the issue, and then you bring in the facts. Once you know what the issue is, then the facts fit in. Otherwise, it's just boring to read through all the procedural stuff. Whereas if you know what the issue is, then it's interesting to know everything else. Okay. Now it's Judge Albie, often feeling very lonely on the court, with fantastic colleagues, brilliant colleagues. And I disagree with them. Who am I to disagree with them? I'm a judge on the court. That's my conscience. That's the way I see it. Or I agree with them, but my reasons are completely different. Very early on, fairly early on, not very early on, we had the Sodomy Case. Our court was unanimous. The idea of sending people to jail because of their sexual orientation was horrific. It was cruel. It was denying people to be who they were. It totally violated our whole new constitutional order. But how do you tell that story? And my colleague, Laurie Ackerman, wrote a very fine judgment, a dignified, powerful judgment, showing the irrationality of it. And one argument that was strongly addressed to us was male penetration of a female anus is not a criminal offense, but penetration of a male anus is a criminal offense. Where's the rationality in that? So I start my judgment, because that's not the reason why I'm signing on to his judgment. Only in the most technical sense is this case about who may penetrate whom where. Stephen Sedley said it's the best opening lines he knows of any judgment. He said that some time ago, so I tried to improve on it, but I don't think I have since then. So you discover the importance of da-da-da-da, those opening remarks. Any of you who are going to become writers, it doesn't matter. It can be a thriller, it can be a novel, it can be a judgment, it can be a legal opinion. Use your opening sentence to capture attention, and you establish a tonality. The Laugh-It-Off case, which I'm going to deal with a little while later. Does the law have a sense of humor? Question mark. Deliberately put there to capture the attention, but do more than just capture the attention. It's not just a tagline. It's making a strong point. So I'm now beginning to smuggle in certain writing styles. I thought I would start my presentation today by saying, every judgment I write is a lie. But you've all read it already. Not fair. And most of my best lines are in the book, and you read the book. So I have to improvise. So the years are going by, and I'm getting into my stride, and I'm changing, and I think the court is changing. I was the one who wanted to take on just about every case. Now I'm a little more reticent. Maybe we take on just one aspect of a matter, we develop it, we leave it to future development. My colleagues now are saying, well, it mustn't be too pedantic and narrow. They're kind of opening up. So there's a more of a osmosis, intellectual osmosis happening. We're kind of equalizing quite a lot more. And we get a sabbatical every 7 years. It's 3 months off, and if you fit it in with court vacations, you can make it 6 months. This is my second, it's going to be my last one now. We have a 15-year term. And I decide, New York, New York, Ford Foundation, away from home, I want to tell the story of life on the Constitutional Court. And if Ford Foundation make me a scholar in residence, we'd have the fun of living in New York, and I can do it. I think it's a story worth telling. I think our experience is so special. And I think back on when I arrive in exile in England, I do my PhD, I get a job at Southampton University, and I was actually the first Nuffield Fellow in Socio-Legal Studies. Does Nuffield still have that program? But then it was totally new. Here we have a room full of people doing socio-legal studies, and I'm sure you could have had more and more people. Then it was completely new. And one wonderful week in Cambridge, studying sociology and sociological methods. Now maybe there's nothing worse than someone who's got a little knowledge, but I still remember Gluckman, who was quite an important intellectual figure then, who wrote about the reasonable man in Barotse land. And he's speaking to us about that and saying the African society, in fact, used rationality. It wasn't just drums playing and voodoo. Very serious, rational thinking in settling disputes. And he said he chose that term in Barotse land to shake up academia in the UK. He had a very bad back and he was lying there. It sounded even more powerful because he's speaking from that prone position. And I learnt about survey methods, phenomenology. Lawyers are very nervous about phenomenology. That's experiential. That's what's it like. How do you experience whatever the rules might be? I learnt about participant observation. I really like that. And now I'm about to write my book, and I think I've been a judge, but I've also been a participant observer. I'm not writing about the theory of the judicial function. I'm writing about the experience of functioning as a judge. You can't take that away from me, because that's my experience. You can say it was clumsy or ineffective, or they're better judges who could have worked in a better way. But in a sense, it's observational, it's recollecting. And one of the deep questions I'm asking myself is, why is it so difficult to write a judgment? If it's simply applying the law and reason to the established facts, it should be fairly automatic. Okay, you spend some time getting the fact, you have some argument about the law, but once you do that, it's A, B, C, D, E, tick-tock, tick-tock, tick-tock. My secretary, Fatima, once, the day before we were handing down a judgment which I'd written, she said, Albie, we've hidden your judgment away because you've already made 26 versions of it. And we know if we give it to you to read, you will make a 27th. And okay, lots of them are just style things, improvements and so on, maybe 4 or 5 major changes. Why does it take so long? Why is it so difficult? And I'm asking this question. And then the bath experience that a number of you picked up on. And I might say I've become a shower person now. So I can't rely on lying in the bath for these deep intuitions to come to me that afterwards get into a judgment and get picked up in the House of Lords in England, get picked up in Canadian Supreme Court. Why do most of my most profound thoughts just suddenly pop into my head when I'm not thinking, I'm not trying? And this puzzled me. Okay, I'm going to put a question to you to see how well you've read the text. I'm lecturing to students at the University of Toronto, and I'm saying this, and I'm saying how puzzled I am. And I start with every judgment I write is a lie. It's a lie because it appears to be written tick-tock, 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 but often the very last words I put in are, this judgment is about. It's only when I've got everything settled and I'm totally sure that I can actually state with confidence what the problem is. So the first words are often the last words. So who helped me in Toronto to resolve that problem? Anybody? It's just a justification for me to repeat what's in the book. Okay, they have a practice there when you're a visiting scholar, which I must say I would recommend to other universities. Every night you're taken out to a different ethnic restaurant by members of faculty for a meal. And I thought they felt sorry for me. This poor guy sitting alone in his hotel. What I didn't realize is every night becomes a seminar. But it's a fun seminar because the conversation flows freely and it's different people from different departments and so on. So the one evening, I think it was Lebanese and it was political science. And I tell them about this dilemma. Why is it so difficult? And they said, oh, no, we understand that, as if to say, we don't expect lawyers to understand, but we're political scientists. There's a difference between the logic of discovery and the logic of justification. Wow. Yes, of course, it's right. It's right. The discovery can come just like that at a moment. It doesn't come from nowhere. You've been beating the bushes, you've been digging up the material, you've been working through it for ages and ages and ages, but it's not resolved. And suddenly you let it alone and boom, the discovery comes. So for me, these would be my bath moments. Now, they don't happen in the shower all that often, but they do come often quite unbidden to me. But to me, there was more to it than that, judgment writing. So, okay, we've got discovery, justification, persuasion. Persuasion is the rhetoric. And anybody who's written a legal judgment, my colleagues who were here this morning would know that. It's the extra additional arguments you put in. They're not necessarily simply for the logic, simply for the pure rationality which is in the justification. But it's the supporting arguments. Now the word rhetoric in English seems rather negative, mere rhetoric. On the continent, rhetoric is persuasive argument. It's something positive. And then the last one, preening. Preening's that bit of pizzazz, that bit of show-off. And it fits in with this notion of judges being the great storytellers of our age. It doesn't mean they tell the story in a great way. It might be boring as anything, but that's a story. If it's stiff and ultra-technical and remote and far away from lives that people lead. That's a story. It's a sad story, but it's a story. If it's real, if it's warm, if it engages with the real issues that really made you decide, if it's candid, then I think it's fulfilling the function that stories should tell in the modern age. So that's the bit about the discovery of discovery. I'm sure you all found that, working with different problems. You battle, you need an organizing principle. Archimedes said, give me a lever and I can lift the world. And judges need that. And if you're writing a thesis, you're going to need that. And if you're presenting an argument, you're going to need that. Something that can absorb all the essential elements, unify them in a principle, and enable you to resolve the issue. The passionate interest in passion, dispassion, and compassion. I'm always feeling, maybe I'm not a real judge, but at least what I'm going to do is tell the story the way I reason it. I did one case that involved a number of issues when Professor Kader Asmal was Minister of Education. He issued a rule saying that private schools can only open their doors to children in the year they turn 7. And a lot of the private schools, the parents there are beginning to tutor their kids in utero. And they have geniuses at the age of 4, and the idea they can't start school at 5 was horrendous to them. But in any event, there were all sorts of arguments against Kader's proposal. But we opted for the most technical. He'd quoted from the wrong statute. And I wrote that judgment with some glee to prove to my colleagues that if I really tried very hard, I could write a boring judgment. Otherwise, people would say Albie's signature is there. He doesn't have to sign. But that one, it could have been anybody writing. And I think this passion, dispassion, compassion make a kind of a triad. As Brennan, who came up with this notion of reason and passion, and he said he chose the word passion because passion sounds like the total opposite of law, of rules, of rationality. And by passion, it doesn't mean I love you, I love you, I love you. It's not frantic and anarchic. Passion, he said, meant compassion. But I would add dispassion. And it means the distinction, to pick up on things that were said this morning, between neutrality and impartiality. Judges should not be neutral in a constitutional state. The Constitution has a set of values. The Constitution does not allow indignities to be imposed on people. The Constitution doesn't allow for torture. The Constitution doesn't allow for expressions of racism. There are a whole range of things. You take a stand. You take a stand. You've got to take a stand. It's your judicial duty. To say you're neutral on torture or neutral on apartheid is not to be objective and fulfill your judicial role. It's, in fact, to withdraw from your judicial role. But at the same time, impartiality is absolutely fundamental. And impartiality means a hearing, an equal hearing and a fair hearing to everybody. And this was fundamental in South Africa, a country of division, of distrust, of automatic assumptions about everybody. We needed at least one body. We are not running for office. We're not looking for votes. That is upholding the Constitution, this core document that's central to our lives, central to our new kinds of citizenship. Let me give you in a few cases, some of which might be in the book, some not in the book, or underline things that are in the book that maybe need a little bit of starring. The Volks case, V-O-L-K-S, dealt with the rights of cohabitants. And there was a law that said it was a law to protect spouses of deceased people where the deceased had made a will, writing out usually his wife completely from the will. And it said that the surviving spouse of a deceased person is entitled to reasonable maintenance from the estate of the deceased. And the question was, the fact that this was limited to spouses, was that unfair discrimination against cohabitants who'd lived as spouses, sometimes for decades, with a deceased person? And we go around the table. My colleague Squia has written the judgment for the court. He said it's not unfair discrimination. If when you're married, once you marry, then you are under legal duty to maintain your spouse. And it makes sense that after your death, that duty continues. Agree, 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 agree. Albie, disagree. What portion of the reasoning do you disagree with? I said the whole thing. His logic was impeccable. It all depended on how you framed the issue. If you framed it as a question of marriage law, he was right. If you frame it as a question of family law, then he's wrong. Families are constituted through marriage, but they're also constituted in practice. So in the case of a surviving partner who could have lived for 40 years with the deceased, brought up 4 children with him, sacrificed her possibilities of going out and earning so that she can live off her own income and have her own home, because she's invested her whole life in the family. Surely it's unfair discrimination to say, simply because she wasn't married, there was no document, she can't be entitled.
We're going to give you 2 more minutes so that we can then give them some questions.
Okay, I'm going to take it a little bit more.
Now we're going to negotiate. Now we're going to, that makes it 3 minutes? You 3.
Now, the people who used to me give me much more warning time than that, yeah. In any event, one consequence of that was I was joined by Cato Regan, and not joined, they also wrote a dissent, but on much narrower grounds. Somebody did a survey of pro-feminist members of the court, and Cato Regan told me that I got a higher score than she did because of the position I took in that particular case. In the Prince case, which dealt with so the issue there I'm putting to you is the importance of how you frame the question. Can the landscape, the legal landscape, can dictate outcomes. In the Prince case, I used the phrase, we judges are not like, we're not functioning as though we are using weightless ropes on a friction-free pulley. And that was to say we are not in an abstract space. We are part of the very world that we are examining. And I was wondering why it was that my colleagues, all of whom would have been quite happy to decriminalize the smoking of marijuana, wouldn't allow the Rastafari a legal right to smoke marijuana, at least for sacramental occasions. What distinguished between us? And it wasn't that my colleagues were undaring. Capital punishment, unanimous. Same-sex relationships, unanimous. Difficult social issues, but here we split. And I felt it's because of our different connections in a way with the community that we were differing. And it couldn't be explained purely in terms of logic. So we both, all of us, applied proportionality and balancing, but some of us felt that the invasion of religious freedom was so profound, and the damage that could be caused to societal interests in the case of smoking marijuana, which was not caused less damage than whiskey or smoking did in society. It's not like heavy drugs and so on. Applying the proportionality test, it was an unfair invasion of the religious rights and freedom, and the majority said no, it would be impossible to police the drug laws without that. Let me finish then with Fourie. That's the same-sex marriages case. In the sodomy case, I'd had a trial run, and it's not only dissents that signify. Sometimes you write a concurrence, but your reasons are different from the majority. And in the Laugh-It-Off case, my reasons for allowing a logo that of Carling Black Label beer, I think it's mentioned in the book, I agreed with the main decision, saying that if you balanced out the free speech interests against the damage to the owners of the label, of the logo, the damage was so small, free speech interests prevailed. But I said, humor is so important in our society. It's so important for democracy. And parody by its nature depends upon appropriating the image. That's its very nature. So I wrote something that's very much following Naomi Klein in terms of no more logos, because that was my reason for saying it, not because of the reasons that had been used. In any event, in the sodomy case, I agreed with my colleague, but I felt the real issue was penalizing people for being different, for lifestyle, for not following the mainstream. And it's not the act that was being penalized, it was the actor that was being penalized for being who he or she happened to be. And I wanted to say that. Now, years later, I'm a more experienced judge, and we have the same-sex marriages case, and my colleagues are thinking, now what's Albie going to do? He said in the cohabitation case that marriage is can just be a mere piece of paper. Is he going to say, let couples live together, let them have all their legal rights, but don't call it marriage? That was the main argument, don't call it marriage. And we had a Mr. Smythe who came to court to argue. As a Christian, he said, it's interfering with my deepest beliefs. And the issue then was, use the M word or not. And yet, to me, that was the key thing. If the love, the affection, the mutuality, public acceptance was equal for everybody, to deny that was a profound indignity being imposed upon the people. I think that was the point that I brought out in the message I sent to the Colombian Constitutional Court. And the whole thesis of equality. Equality is equal treatment across difference, not through suppressing difference. As long as you're like the others, we're not going to discriminate against you. But you come in as you are, with your difference of language, culture, religion, sexual orientation, whatever it might be, and you are treated with equal concern and respect. That's the foundation for equality. And we must see difference not simply as something to be tolerated or put up with, at the very least to be acknowledged, and at best as a source of vitality in our society. Difference actually enriches our society. In any event, as the colleague from Colombia mentioned, a lot of the decision dealt with the sacred and the secular. Now this is addressing the nation in a way, because there are millions of people out there who find it very hard to accept, for religious beliefs, whatever it might be, that same-sex couples should have the same right to express their love publicly as heterosexual couples have. And you don't draw a line between we, the enlightened, and they, the benighted. You try and address the whole nation. And I felt this was important as part of the educative role that the judges can play. And it was easy for me to write in very strong terms about the importance of religion for millions of people, because I am secular. For me, being secular was part of my conscience, of my makeup. I had to fight for my right not to pretend to believe in God. When I was a child, if I didn't have it, it would be disrespectful to me and disrespectful to God if God exists, if I'm pretending a belief I don't have. So conscience is number one. Conscience comes first. And you respect that in others. But to argue in favor of the coexistence of the secular and the sacred in the one country. And the South African Council of Churches called it a Solomonian judgment. And I was happy because my dad was Solomon. That was a nice little personal touch. But that was exactly what I was aiming at. The people could feel they've lost their case, they've lost their argument, but they've been taken seriously, they've been listened to. And I think that's what the role of a court should be, and the role of a good advocate should be. And just to end, a month or 2 weeks after our parliament accepted the ruling of the court, and in a rather curious way, but nevertheless allowed same-sex couples to go to the marriage office and say, I marry you. I'm driving in a place called Kirstenbosch, very family-oriented gardens in Cape Town, and I'm looking for the sign, and the sign says, to Amy and Jean's marriage. And I felt fantastic. And I'm still kind of glowing with this, and my book comes out, and I'm sitting at the University of Cape Town. I've given a public lecture there. There's a guy in the queue. He wants me to sign his book. You won't remember me. And as soon as he opens his mouth, I realize he was Mr. Smythe, Advocate Smythe, who'd argued before me in the court. And in my judgment, I'd said, you can't allow scripture to be the basis for court decisions. Imagine what the churches would say if the judges are interpreting, and there's enough dispute between the theologians themselves. We can't allow that, but we don't doubt his sincerity. But there must be coexistence between the sacred and the secular. And he said, would you mind, Justice Sachs, please signing my book? And I signed that book, and I felt, in that sense, that little area, mission accomplished. Thank you.